The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. All right, the first case we'll call this morning is Spivey versus Breckton, and Ms. Graham, we'll hear from you.
Good morning, and may it please the court. Wing Muscatine Graham on behalf of appellant Mandrius Spivey. This appeal concerns the narrow question whether Mr. Spivey has a Bivens cause of action for his claims that defendants failed to provide any medical, mental health, or dental treatment to him for nearly a year. These are textbook Eighth Amendment medical care claims, and he has a cause of action for each of them. Though the Supreme Court has instructed lower courts not to extend Bivens, it has also made clear in case after case that Bivens claims remain available in previously recognized contexts, including Eighth Amendment medical care claims.
That might even be overstating it. They've said, for instance, if we had Bivens today, it probably wouldn't be the law. And the underlying pressure that the court feels is that it doesn't feel like the third branch is in the position to create causes of action under the Constitution. And so they've been pretty strict on that.
That's true, Your Honor, though they've also said in Ziegler, again in Hernandez, and again in Egbert, that the three previously recognized contexts still remain available, even if
I know what they said, yeah.
And Mr. Spivey's claims fall squarely within Carlson. So for this court to come to the conclusion that he doesn't have a cause of action under Carlson would contravene Supreme Court precedent.
Carlson's medical claims seem to be much more serious than the ones in this case.
Respectfully, Your Honor, the seriousness of the medical care claims shouldn't bear on the first step of the Bivens analysis, and that's because they don't implicate the kinds of considerations that the court has instructed lower courts to consider at the first step, namely factors that bear on the separation of powers and judicial intrusion into the operation of other branches. And this court's decision in Hicks makes that clear. So Hicks was a Fourth Amendment case involving—
Except right in green, they talked about the basis for the cause of action being a survivorship claim. And they spent a lot of time talking about where the survivorship claim would come from, what it would look like. And of course, there was a death there for a lack of medical care. And we don't have a survivorship claim here. We have a claim of delayed medical care. I mean, the tooth was treated. It was late. He was put on a list. And the bleeding, apparently, they took a test and didn't find anything. And and the tooth that broke, he pulled out the rest of it and didn't complain in the complaint about anything further. There was no treatment necessary on that. So none of that was life-threatening, and we weren't looking at a survivorship action. But the court used the word survivorship action and rested the whole claim on that issue. I think that's fairly different context, isn't it?
Respectfully, Your Honor, I disagree. So in every time the Supreme Court has characterized Carlson in the years since, it's referred to it as an Eighth Amendment medical care claim challenging deliberate indifference to serious medical needs. That's how this court understood the Carlson context in its own case in Macias, where the plaintiff suffered from an ankle injury, hernia issue, nasal infection that he claimed needed surgery. Those were similarly very different contexts than the claim in Carlson, and still this court came to the conclusion that the plaintiff in Macias had a cause of action under Carlson. And the same is true for Hicks, where it's a Fourth Amendment claim, but nevertheless, this court found that although Park Police who did the search, conducted the search, and they were traffic stops rather than a home arrest, as in Bivens, still the court found that the plaintiff in Hicks had a cause of action. So for the court now to conclude that just because the kinds of claims that Mr. Carlson brought differed in some ways from the claims in Carlson, that would be inconsistent with Hicks. It would be inconsistent with this court's decision in Macias as well. And I'll add that the Supreme Court has repeatedly said that it's characterized Carlson as Eighth Amendment medical care claims. So and each time.
Well, that's a handle to refer to Carlson, but they've also explained that Eighth Amendment claim is just too broad. There are lots of different types of Eighth Amendment claims, and I don't think you can get a lot of comfort from that.
Well, Your Honor, the court has given lower courts ways to distinguish claims from Carlson if they involve, for example, the factors that the court laid out in Ziegler, so rank of officers, judicial guidance that's given to prison officials and medical care providers. But those are not the kinds of factors we have at issue here. So while there are ways to distinguish Carlson claims, none of those factors are present in this case. For example, the kinds of officers in this case are the same rank as those in Carlson. The right at issue, of course, is the same. The generality and specificity of the claims are the same. That Mr. Carlson is challenging prison officials' failure to provide him with specific kinds of medical care, rather than he's not challenging major policies or systemic prison actions. The judicial guidance is the same. The courts have been very clear that that prison officials must provide a minimum level of care. They can't be deliberately indifferent. So all of these factors that Ziegler has laid out would counsel in favor of recognizing a cause of action here. And again, that's exactly the same as this court has already done in
And
Hicks.
the excessive force claim, you agree, is covered by the court's recent Goldie opinion. We don't need to cover that.
That's right, Your Honor. Yes, we concede that. I'll add, Your Honor, that in Ziegler, the Supreme Court made very clear that although, to your point earlier, that the court has said that Bivens wouldn't necessarily come out the same way today, it said that it must be understood that the opinion in Ziegler is not intended to cast doubt on the continued force or even the necessity of Bivens. It was, of course, talking about the search and seizure context, but the same, I think, is true in the medical care context. And for this court to come to the conclusion that there's no Carlson claim available here would effectively preclude all Carlson claims, which, again, would be inconsistent with the Supreme Court's instruction time and again to recognize Carlson claims. I think there's no way to square that holding with the Supreme Court's instruction again and again. And several of this court's sister circuits have come to the same conclusion. So the Ninth Circuit in Watanabe and Schwartz have explained why medical care claims may continue to proceed under Carlson, even when they're not claims involving a death. The Seventh Circuit in Brooks and Watkins has made the same case. This case just falls squarely in that context. So although the severity of the claim is slightly different, it doesn't implicate any of the factors that the Ziegler court laid out or any other reason to be cautious on the first step of Bivens. Again, we're not talking about the second step, we're just talking about the first step. If there are no further questions, I'll.
All right, thank you.
Thank you.
Mr. Taylor?
Good morning, Laura Taylor on behalf of the United States. May it please the court. If I understand my opposing counsel correctly, they have conceded counts 1 through 4 and count 9 as being governed by Goldie. That leaves only the medical care claims in counts 5 through 8. And Goldie has indeed winnowed those claims as well, because the reasoning in Goldie would require this court to find that if the counts present a new context, then there are special factors that counsel hesitation, and all of counts 5 through 8 would fail at step 2 of the Ziegler test. And so that means that the only remaining question for this appeal is indeed whether counts 5 through 8 present an old context such that they may proceed under Carlson, or whether they are meaningfully different from Carlson and thus present a new context and are prohibited. I will focus the majority of my argument on that point, but I will note, however, that the government has also argued as an alternative argument that in the event the court were to recognize counts 5 through 8 as viable implied causes of action, that the defendants have asserted a qualified immunity defense that this court could and should resolve at this stage as well. Whether counts 5 through 8 present a meaningfully...
The district court didn't reach qualified immunity, did it?
It did not, Your Honor. Yes. An alternative would be to remand for that consideration in the first instance, but because this court can affirm on any basis in the record, and the defendants have moved based on the pleadings that the complaint cannot overcome qualified immunity based on the allegations, then under this court's precedent, it would be proper for this court to rule on that ground in the first instance as well. Whether the medical care claims are meaningfully different from Carlson turns on whether or not there is any minor difference to say that they present a new context. The Supreme Court has made clear that significant parallels are simply not enough. And a difference can be meaningful whenever there is a factual distinction or a legal issue that might alter the policy balance that had implied the damages remedy in the first place. Now, admittedly, the Supreme Court has not provided a lot of guidance on how to quantify or qualify meaningful differences, but the Ziegler factors do give this court guidance. The first factor is the generality or the specificity of the official action. The second factor is the extent of judicial guidance. The third is the statutory obligations under which the BOP officers were operating. And the fourth, and most importantly, is the risk of disruptive intrusion by the judiciary into the functioning of the BOP prison system. Now, of course, Carlson allowed for some intrusion by the judiciary into BOP's prison functions. But the question for this court today is based on the allegations that Spivey makes, whether his claims threaten to intrude in ways that Carlson did not contemplate. And it is a government's position that is exactly what Spivey's claims do. They threaten to intrude on the functions of the BOP healthcare system in ways that Carlson did not contemplate. And because this court would have to reweigh the cost-benefit analysis.
Giving someone the medical care they need will intrude upon their administrative matters. Someone is bleeding out and to give the proper treatment to that person would somehow upend their administrative duties and policies? How so?
Respectfully, Your Honor, this case does not present that question. Mr. Spivey was not bleeding out.
Yeah.
But to answer your question, I think in the spirit with which you are asking.
It's a hypothetical, obviously.
Sure. The government recognizes that there is some sensitive line drawing around where differences could be meaningful. But in Carlson, you had acute acts of individual malfeasance. The defendants in that case administered contraindicated drugs in a life-threatening situation and then knowingly used broken equipment, which further escalated the death. Those are very specific acts for which the risk of a disruptive intrusion into the BOP healthcare system by the judiciary is low, because under no circumstances would those activities be acceptable. But here, the questions that are presented target much broader level issues, much more systemic issues at BOP. For example, the mental health care request implicates programming considerations. Mr. Spivey states that he wanted to have a pre-release psychology class. That questions whether or not programs should be offered within the prisons, who should qualify for those programs, what type of application process to get admitted to those programs is acceptable, and whether or not mental health care programs for pre-release or at the time of pre-release are even a necessary constitutional obligation. All of those considerations are much more akin to the administrative questions that were presented in Bulger and Nelson than they are to the acute acts of individual malfeasance in Carlson. Moreover, Mr. Spivey's claims simply don't implicate the type of judicial second-guessing that was appropriate in Carlson. In this case, for example—
Well, there's something I alluded to in my first questioning. The court said, what kind of cause of action are we going to have? And they said there was an argument as to whether to use federal law or state law of survivorship, and the court said, whatever difference we might have in resolving the question whether where the federal involvement is less clear, we hold that only uniform federal rule of survivorship will suffice to redress the constitutional deprivation here alleged and to protect against repetition of such conduct. And it then adopts a reasoning in the lower court which basically creates a survivorship cause of action. That is entirely distinct from the nature of the claim here, which is not a survivorship claim. This is a claim for delay in providing medical care.
Yes, Your Honor, we agree with that. For the most part, Mr. Spivey's claims allege delay in providing medical care. Some of his claims also allege that BOP should have different policies and procedures regarding on-site providers or on-site programming. And those two different types of claims are not exactly similarly situated, but they certainly are both different than a survivorship claim, as Your Honor identifies. And in that sense, all of Mr. Spivey's claims are nowhere close to the same context as Carlson. Focusing on the Ziegler factors, and most importantly, the generality or specificity of the action and the commensurate level of intrusion that would take place into the BOP healthcare system, to Your Honor's point, Carlson had a tragic, life-threatening situation that resulted in death, and that's why there's a survivorship claim. But it wasn't just delayed medical treatment that resulted in the death in that case. It was very specific acts of malfeasance that were done by individuals, including contraindicated actions. In Mr. Spivey's case, the complaint is at a very general level. His allegations are not specific, nor does he allege specific misconduct that amounts to individual acts of malfeasance by any single BOP employee. For example, taking issue with the warden's decision not to have an on-site dentist is nowhere near the same as providing a contraindicated drug to a dying inmate. And so for all of those reasons, and because any minor difference provides for a new context, the government would ask that this court heed the Supreme Court's warning and find that Mr. Spivey's claims do indeed present new context, and the special factors preclude an implied remedy here under the reasoning of Goldie.
So are you saying that none of his claims involve acute care issues and neglect? None of them?
Not as they are pled, Your Honor. In fact, in all of the medical care claims that Mr. Spivey pleads, he never once alleges that his condition worsened, that he received a subsequent diagnosis, that he eventually needed medical care, such as surgery or life-saving equipment of any kind. In all of his claims, his conditions improved or went away. He doesn't allege otherwise. And essentially, Mr. Spivey alleges, I had some level of pain, I communicated that to BOP, I'm dissatisfied with the response I got, but then nothing ultimately came of it. And of course, the heartland of a deliberate indifference claim under the Eighth Amendment, if it were to proceed to trial, is that the plaintiff has to prove that he had a serious medical condition and the defendant knew about it and also knew of an excessive risk that was posed by the alleged inaction. Here, it is hard to imagine how any excessive risk could have been posed by the alleged inaction when Mr. Spivey himself does not allege that any risk materialized. This is simply not the case, thankfully, of a tragic outcome, and thus it is a very differently situated case than the facts and circumstances of Carlson.
So you're not saying you have to die in order to have it's not a new context, as long as you show that?
No, Your Honor. I don't think the government's position is that there has to be a death in order for...
It seemed to me, under
Could you answer my
Carlson,
question, please?
under Carlson, the court created a new cause of action under the Constitution, recognizing it. And the new cause of action it created was survivorship action. And it spent a couple of pages discussing that.
Is that your response to you incorporate that?
Yes, Your Honor. And I hear you, Your Honor. I don't know that I'm authorized to state whether or not DOJ thinks the fact that it is a survivorship action alone is sufficient to create a new context. I recognize that it is indeed a very differently situated procedural posture and may well constitute a new context. I don't know that I have the authority to say that alone is dispositive. However, to your point, Judge Gregory, about whether or not a death is required, the key focus there is that in Carlson, you had such specific contraindicated actions by the BOP employees that caused the death. And it is the government's position...
We don't need to answer that question to decide this case.
That's correct, Your Honor.
Which I did ask it, so you do need to answer.
I'm happy to answer it. I can imagine a scenario perhaps where life-saving measures are successful in the last instance. Right. And we would still and there may still therefore be an argument that there was deliberate indifference up until the last possible moment where CPR may have been successful, for example. Perhaps that's a difficult question that should be answered on a different day, but I'm certainly not going to tell you, Your Honor, sitting here today, that that's absolutely foreclosed under the current Bivens framework. But we are nowhere near that line today. The government recognizes, of course, that there is sensitive line drawing in this question, but thankfully the line that has to be drawn today is not quite so thin. It's not nearly so nuanced because Mr. Spivey's allegations are so indeed generic. And the level of intrusion the judiciary would have into BOP's healthcare system if it makes this type of mine-run Eighth Amendment claim actionable would be so significant. And so because you would have to reweigh those policy considerations, and even if you ultimately weighed them differently, it doesn't matter. The fact that you would have to reweigh them means that under Supreme Court precedent, you cannot recognize a new context. And therefore, Mr. Spivey's claims should have been and properly were dismissed by the district court.
Okay. Is
Thank
that
you.
it? Thank you. Ms. Graham?
Your Honors. I'd like to push back on a couple of the comments that counsel on the other side made. So the first thing is that I think it's a bit of a red herring that Mr. Spivey's claims here challenge policy considerations. With respect to the dental care point, he explicitly said at pages 30 and 31 of the joint appendix that he's challenging the defendant's failure to provide him any dental care whatsoever, although he mentions that the defendants responded to his requests by noting that there was no dental staff on site. He explicitly says that they didn't provide him with any treatment, and he lists several ways that they could have provided him with treatment, one of which is providing a dental staff member on site, but also by sending him off site, contracting with dentists, etc. In terms of the question of the severity of his claims, severity is a question that gets to the merits of his claims, potentially, and there are many ways for a plaintiff alleging deliberate indifference to medical needs to lose on the merits. It's just not relevant to the first step of the Bivens analysis. Although Carlson was a survivorship claim, the court has, to my knowledge, not focused on that ever in discussing Carlson in the years since. That's to say that there have been many Carlson claims brought pre-Ziegler, pre-Egbert, and post both of those cases. And to my knowledge, survivorship has never been highlighted. And so I think it would be wrong at this point to characterize a Carlson claim for the purpose of Bivens' first step as just the survivorship claim. And I'll respond as well to counsel's comment that recognizing a Carlson cause of action in this case would open the door to many more Carlson claims. Carlson claims have been recognized for over 40 years. There's never been such an issue. And these courts deal with many, many more 1983 medical care claims. In the Bivens context, there are many fewer, just by virtue of there being many fewer folks in federal prison. So I don't think that should animate the court's decision here. And I'll just add that Mr. Spivey's claims, again, the severity of claims I think get to the merits, but I'll note that while he didn't die, he did suffer from severe pain, including severe dental pain, which this court has recognized to be serious, and several sister circuits have repeatedly recognized severe dental pain to be a serious condition. The Eighth Amendment is grounded in part in preventing the unnecessary infliction of pain, so the fact that he endured nearly a year of no dental care. He was diagnosed with some of his dental conditions prior to his incarceration at USP Lee. He was there for nearly a year, didn't once receive pain, didn't once receive treatment. His conditions were so bad that his tooth fell out. That is, I think a very serious allegation. And he also alerted defendants about his severe dental issues, and also some of the severe pain that he was experiencing from his other conditions. So again, those questions I think do get to the merits, but I would point out that he did make out claims that he was in serious condition. And finally, to the question about the district courts reaching qualified immunity, the district court didn't reach qualified immunity as you noted, and that is a question that we think the district court should touch in the first instance. So all we're asking here is for this court to recognize that Mr. Spivey has a cause of action under Carlson and send the case back to the district court to deal with qualified immunity and the merits in the first instance. Thank you.
Thank you, Ms. Grant. We'll come down and greet counsel. Please proceed to the next case. Next case we'll hear this morning is United States versus Mosley, and Mr. Stolker, whenever you're ready, we'll hear from you.
Good morning. May it please the court, my name is Richard Stolker. I was appointed by this court to represent Clifton Mosley in this appeal, and I thank the court for that appointment. In our brief, we raised a number of issues. With the court's permission, I'd like to address the issue of sufficiency, which I believe is the most intriguing issue in this case. I say it's intriguing because the government put on a ton of evidence. They put on 38 or 39 witnesses. They introduced over 300 pieces of evidence, and the case was tried over a 3-week period. And yet, it's our contention that the government totally failed to prove the elements of the crime with which the crimes with which Mr. Mosley was charged sufficiently as a matter of law. So I'd like to address those issues if I may. First of all, a great deal of the evidence in the case centered around cell tower locational information, that is where certain cell phones were purportedly located at important time frames in the case. There was no evidence put on at all that the cell phones that were registered to Mr. Mosley and to Mr. Carter were in fact on their persons at the critical times that the government contended at the time and place of the shooting. Each of these individuals had multiple cell phones. They had burner phones. They had phones that belonged to girlfriends in some cases. And in the case of Mr. Carter, for example, his cell phone never left his home. His principal cell phone stayed in his home during the time of the shooting. He had a different cell phone on his person. The FBI agent who presented most of the cell tower locational information, Agent Wild, conceded that the cell phone tower evidence can only show roughly
I want to make sure I
where.
understood what you said. That Carter's cell phone was always on Carter, or Mosby's cell phone was always on Mosby?
At the time of the shooting, Carter's registered cell phone, I'll use that term, was not on his person. It stayed at his residence. Then after the shooting, Carter goes to his home, or maybe never left his home, takes his cell phone and goes to Myrtle Beach. I don't think that's a critical issue, but I think it's
I just
simple.
want to make sure which one you were talking about. I just missed it.
No, not Mosley. The FBI agent, Wild, also conceded that cell tower locational information is not terribly specific. It doesn't identify exactly where somebody is. Cell phones don't necessarily ping the nearest tower. They ping the tower with the strongest signal, which may not be the closest tower. It's possible there's a tower here, but a building blocks the line of sight, so the cell phone pings a tower a quarter mile or whatever away. It's also, and I think this gets more to our central point, the presence, even if the cell phones establish, and I don't think they do, but even if they establish that the individuals were in the neighborhood where the shooting occurred, that's all it shows. It doesn't show that they were that Mr. Carter was the shooter, as the government theorizes. It doesn't show that Mr. Mosley was the presumptive getaway driver, as the government theorizes. This was a neighborhood in Baltimore City where the defendants, Carter, Mosley, and also Hightower, who was incarcerated at the time, had been selling drugs, had been selling marijuana and sometimes other drugs over a long period of time. It wasn't unusual for them to be there. The connection to the shooting is what the government asked the jury to theorize, as the government had. They're in the neighborhood, so they perhaps, probably, maybe, I don't think beyond a reasonable doubt, must have been the shooters. It's important to recall that the only witness who actually saw the event was a witness named Murray, and the best she could do was to say that she saw the shooter shoot the decedent, Miss Ashburn, and then leave the area, run or walk away very quickly, but she could only describe the individual as a tall black man with a hoodie and jeans. I submit that that description could fit half of the population of Baltimore or half of the population of any city. She was not able to identify Mr. Carter from a photo array, and that's all the government had in terms of identification. They had a Pontiac Grand Am sitting in an apartment parking lot nearby. The vehicle was registered to an associate of Mr. Mosley, and from that, the government theorizes that he was the presumptive getaway driver. There was no traditional forensic evidence. They did recover a bullet from the decedent's body, but there was no weapon ever found that matched up with that. There was no any kind of forensic evidence. There was no video recorded that showed anything more than a grainy picture of somebody undescribable in the area. So what we're left with is individuals, Mr. Carter, Mr. Mosley, in the area, not unusual, where a shooting occurred. There was a case that I saw only last night at 9 o'clock when I arrived in Richmond, because it was decided yesterday, by the name of Hawkins, Tremaine and Hawkins. It's number 244502. And it was decided just yesterday, opinion written by Judge Benjamin. It was a Fourth Amendment case, but there's some language in there that I thought was particularly pertinent to this case. This Hawkins case was a traffic stop. And the language in there that I wanted to direct the court's attention to is, and I'm paraphrasing because I don't have the exact case in front of me, the courts are skeptical of government attempts to spin mundane acts into a web of deception. The court also goes on to say that anything less would invite intrusions upon constitutionally guaranteed rights based on nothing more substantial than inarticulate hunches. Now that maybe overstates a little bit what we have in this case, but we really don't have anything constituting proof. What proof is required under section 1512 and 1513 is that there has to be an intention to prevent a witness from providing testimony or appearing at a proceeding. That's the critical element that's missing. Where is the evidence that Mr. Mosley, or for that matter, Mr. Carter, intended to silence not the person who was shot, but the person who they, under the government's theory, intended to shoot? There's no evidence in the case that there was a discussion between Mr. Hightower and Carter and Mosley about the intended witness, whose name momentarily escapes me. I'm sorry, I can't remember her name at the moment.
Lisa Edmonds, you mean?
No, I don't think that's correct. Lisa, I'm sorry, I don't remember her name. But in any event, there's no evidence that there was any discussion. There were discussions between Hightower, even when he was incarcerated, and Mosley and Carter. They had frequent discussions. They met, they had breakfast together at the IHOP. They talked on the telephone, they texted each other, they met up, but that's doesn't take you anywhere because they were in the business of selling drugs together. There's no evidence that they discussed, I think her name, I'm sorry, I still don't remember her name, but there's no evidence that Hightower asked or even intimated that Carter and Mosley should take out.
Lisa Edmonds. It was Lisa Edmonds.
Lisa Evans, okay. Thank you, I'm sorry, I couldn't remember it. There's no indication that there was this plan in progress that the government theorized. At best, we have individuals who are in the area, they're selling drugs on a regular basis, they're in touch with each other. The frequency of communications between Carter and Mosley increased when Mr. Hightower went to jail because he was their supplier. But he wasn't the only supplier. They had another individual, I believe his name was Sheldon Grant, and there were, I'm sure, no shortage of marijuana suppliers in Baltimore City from which they could have purchased their product for resale.
Was there evidence that Lisa Edmonds was cooperating or assisting the police in any way?
Yes. She was the one that reported Mr. Hightower's alleged fraud. So, yes. Does that answer Your Honor's question?
Yes, thank you.
Yeah, okay. Beyond that, unless the court has any questions.
All right. Thank you, Mr. Stalker. You have reserved some
Yes, I
rebuttal
will
time.
reserve the
Yeah.
balance of my time. Thank you, Your Honor.
All right, Mr. Manager.
Good morning, Your Honors, and may it please the Court. I'm Jason Mettinger, and here on behalf of the United States. Your Honors, the jury properly convicted Clifton Mosley for his role in the murder of Latrina Ashburn and for the offenses charged in the indictment. As such, we respectfully ask that this Court would affirm. Because my colleagues started with sufficiency, unless the Court has different questions, I'll start with that issue. That issue, as you know, is a very steep hill to climb for the defendant. The jury, as you heard more than 30 witnesses, more than 300 exhibits. There's an enormously heavy burden that a defendant has to surmount in order to countermand a jury's finding here. And the jury here found that Mr. Mosley was guilty of the offenses for which he was charged. And I'll just dwell briefly on some of the facts that the government presented, because my colleague mentioned, cell phones. That only tells a very small slice of the picture. And you have to look at things wholly in the totality of the circumstances. And here, I think you have to start with the relationships. You have to start with the fact that we established that there was a relationship, both a business relationship and a friendship, between Mr. Hightower, who was at the apex of a drug trafficking conspiracy. He was then assisting his, what are called right-hand men, his lieutenants, if you will, Mr. Davon Carter and Mr. Clifton Mosley. So they were in this friendship, they were doing drug trafficking together. The testimony proceeds that Mr. Hightower relayed to both of them that he was in trouble. He was having legal trouble because he had a healthcare fraud case that was being presented against him. And so the testimony then came in that Mr. Hightower ultimately was detained, and that was an existential threat to both their friendship because he was potentially going to go away to prison for a while, but also an existential threat to the drug trafficking. And so Mr. Hightower recruited Mr. Carter and Mr. Mosley to eliminate Miss Lisa Edmonds. She was the intended target because she was cooperating in the healthcare case. And so the testimony come in, there's jail calls of Mr. Hightower saying he has to put some things in motion, code for trying to eliminate Miss Edmonds. Move further down the track, Mr. Hightower ultimately is detained. After he is detained, then Mr. Carter and Mr. Mosley take over the drug business, and there's jail calls to that effect. But to ultimately get Mr. Hightower back on the board, to get him out of prison and to make the healthcare case go away, they have this conspiracy to murder Miss Edmonds. Unfortunately, here, they murdered the wrong individual.
And
They-
what was the evidence that they agreed to kill Ms. Edmonds?
So there's a number of indications that that was the case. So there was first the call that I mentioned. This is, I think, March of 2016.
And what did they say on that call with respect to wanting them to kill Ms. Edmonds?
So the call that is Mr. Hightower saying, I have to put some things in motion.
Yeah, you said that.
So he says that. Then later down the track, there's a May 16th, 2016 call, and this is the one that was being adverted to about how they were meeting. Mr. Carter and Mr. Mosley are at an IHOP having breakfast. Mr. Hightower is detained at that point, and the call comes in, and they all speak together. This is the point at which Mr. Mosley tells Mr. Hightower, I've got everything covered, you're going to beat your charges. I'm going to hold you
I have
down.
everything covered, you're going to beat your charges.
Yes.
Anything about murdering anybody?
They were not expressly saying, we're going to help you beat your charges by murdering somebody.
No, implicitly, really.
Well, even implicitly, the jury certainly is allowed to take the inference that I'm going to set things in motion.
Well, you can't, well, the jury, I know we take all inferences, but inferences are based on some facts. It's in the sense that, based on what you're saying, you don't have any conversation where they agreed to murder her. Is that right?
So
Is that
express
right?
conversation.
Wait a minute, is that right?
It's correct, and I'm trying to answer your question accurately. Express conversations about we need to murder, or we need to off, or we need to get rid of Miss Edmonds. They don't say that expressly, no.
Okay.
What I will tell you that we do have, Your Honor, is a number of indications. There was another co-defendant, Miss Miles, in the healthcare fraud case. There were conversations between Mr. Hightower and Miss Miles saying, we think Miss Edmonds is the snitch. We think she is the one behind this. She's telling on us.
And who's saying that?
That is Miss Miles.
And
She's repeating what Mr. Hightower said to her.
We think she's a snitch. In other words, we think she's the person who implicated me in the Medicare fraud situation.
Correct, yeah. Miss
Right.
Miles is saying that Mr. Hightower said Miss Edmonds is the snitch. And so that testimony came in front of the
So
jury.
that goes to, I guess, motive?
It goes to
That
motive.
goes to motive, right?
But it also goes to the, as we were talking a minute ago, Your Honor, about the inferences that the jury can draw. So you have this conversation to say, we think she's the problem. You also have the drug conspiracy between Mosley and Carter. There's also some testimony from some other individuals where an associate of Mr. Davon Carter, this is Clarence Simpson, he's indicating that Davon Carter said, somebody has been telling on Matthew, and he's got to go handle it. And so again, the testimony is, the inference is, this individual heard from Davon, I have to handle a situation because someone was telling on Mr. Hightower. So, you know, that is a small slice of the evidence. There certainly is quite a lot more. There's also the activities that they engaged in. Mr. Carter gets a new burner phone to try to hide his activities. You see Mr. Mosley, who had no reason to look up Miss Edmonds. He looks up Miss Edmonds in the Maryland Judiciary case search, trying to find out where she lives. There's those calls between Mr. Carter and Mr. Mosley. There's the surveillance video that put the various cars that they were using at the scene. There's obviously the historical cell site, which we've discussed. There was also post-murder evidence of guilty knowledge in our view. So we have Mr. Mosley, who's lying to his girlfriend about his whereabouts on that morning. He's also ignoring her phone calls so that they could just focus on their mission. Interesting that Mr. Mosley deleted all of his texts with Mr. Hightower after the murder to sort of cover his tracks. There's also the admission to Mr. Mosley's girlfriend that it might not be over for me. They arrested Mr. Carter first. Mr. Mosley, I think, was worried that law enforcement was going to figure out eventually his role in all this, and he said it's not going to be over for me. So you put sort of all those pieces of evidence together, and again, as you know, this is a very lengthy record. We think we more than meet the sufficiency standard here. Again, it's a very low bar that we have to meet. So there certainly are other issues that have been raised in the briefs. I'm happy to address those questions if the court has any. But of course, if the court doesn't have any further questions, I'm happy to yield the rest of my time.
Okay. Thank you, Mr.
Thank you, Your Honors.
All right, Mr. Stoker, you have some rebuttal.
Thank you, Your Honor. Just briefly, I just want to comment on a couple of things that the government said. That Lisa Edmonds, been their position from the beginning that Lisa Edmonds was the intended victim. That's really a matter of speculation. We don't know we don't know that Laura Ashburn wasn't the intended victim. All we know is that somebody was shot. We don't know who shot them. There's some speculation that it was Mr. Carter, but maybe it wasn't Mr. Carter, or even if it was Mr. Carter, maybe it was because Laura Ashburn was the intended victim. We don't know. The jury was asked to speculate, and we don't believe that amounts to proof beyond a reasonable doubt. Mr. Medinger also mentioned that Mosley did not, or he said that Mosley told Hightower that we have everything covered. Well, that's not exactly what he said. He said that he told Mr. Hightower that Hightower was going to beat his charges. That sounds like encouragement. He said to Hightower, everything's going to be good, yo. You know what I mean? I'm going to hold you down. You know what I mean? That sounds like encouragement to somebody who's accused of a serious crime. It's a long way short of saying, we'll take care of taking out the main witness who's going to testify against you. That's quite speculative to make that leap of faith. Mr. Medinger also mentioned that Mr. Mosley had looked up Edmonds on the Maryland Judiciary site. I think that's understandable. One of his very good friends is accused of a serious crime. Why not see who the witness was? Maybe she was in some other legal trouble that would be helpful for Mr. Hightower to know about. Again, speculation. Beyond that, we would rely on the arguments that are in our brief, unless the court has any other questions. We did not address severance. We did not address the Fourth Amendment issues. We're certainly not abandoning those. I'm here to answer any questions the court may have about those matters. If the court does not, then we would submit. And I thank the court for appointing me and for its attention this morning. And we ask that Mr. Mosley's sentence be set aside. Thank you.
Mr. Stoker, I want to acknowledge and thank you for your representation. You know, this is a very important aspect of our whole system, and it's a
Thank you, Your Honor. It's a pleasure to serve.
Serve the court. We thank you for your service. And
Thank you.
Do you want a little? Okay, you want to take a brief recess? 2 minutes. Okay. I'm going to take a little brief recess. All right, we'll come down, take a short recess, come down and greet counsel.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. Next case we'll hear this morning is United States versus Umedi, and Ms. Thomas, I guess we'll hear from you first.
Good morning, Your Honors, and may it please the Court. Jenny Toma for Ebuka Umedi. I'd like to begin with the jury selection issue. The district court erred in 3 ways in denying Mr. Umedi's motion for a new trial based on the statements made by Mr. Kodish during the jury selection about his personal knowledge of the crimes and the defendants at issue in the case. The first reason is because the jury heard extraneous information, is information that occurred outside the trial in the case. The district court was therefore obligated to address it and to investigate its impact on the jury and to find out whether or not it was prejudicial. But the district court did not address it at all. He didn't do anything, took no curative measures, and that was the first error.
Why would the court think that these are the comments by Mr. Kodish?
Mm-hmm.
Why would anyone think they were prejudicial?
Because he stated that he was familiar with the defendants who were on trial and the crimes in that case because he'd taken part in some of the remediation measures as a cybersecurity expert. So he had worked on the remediation of these
So
crimes.
we might have done some of the remediation,
Mm-hmm.
and I've heard of the defendants and some of their previous involvement in this industry. How does that indicate any knowledge or thought of guilt or actions?
Well, if he's working on the crimes that occurred, if he's worked on them, then he's aware of the defendants as people who perpetrate these schemes. I think it's a very easy connection to make, and it's one that certainly I would have if I were seated on that jury or on the veneer. I think that's a very, very prejudicial and it's a prejudicial thing to say.
Help me understand why, because even he says, I know the defendants. He
So-
doesn't express any judgment one way or the other about it.
I think if he had only said, I need to be recused because I worked on these crimes that occurred, I don't think we'd be taking the same position. The problem is that he connected it to the defendants, these defendants.
Connected what?
The business email compromise schemes that were actually at issue.
I thought he said that the industry connected them to the industry, didn't he?
Yeah, I believe he's referring to the
They're in
industry
this industry.
of committing illegal business email compromise.
industry-
Well, that's your take on
Yeah.
this. There's nothing in the record that says that.
Well, they certainly weren't employed legitimately in the industry or anything like that. I don't think there's any other inference you could draw from a statement like that with this case.
They could have been helping remediate.
I don't believe the jury heard any evidence to that effect.
Well, this is, the second question in the voir dire, and the jury knows almost nothing, and they are asked many questions thereafter whether they can render their verdicts based on the evidence, and
That's true.
And they hear the evidence,
And I would point the court to a couple of things with regard to that. I mean, in a different case, in a different scenario, that might not be an issue that I would press, but here I think it's particularly important for 2 reasons. The first is that these are laypersons who are seated in the jury pool. These are not, you or I who understand the difference between what we're hearing during jury selection versus what's occurring in the same courtroom immediately afterwards in a trial, right? And so these folks are relying on the judge to let them know if and when they hear something that's inappropriate or that they shouldn't take any inference from. They're not experts in any way. And so it's important, particularly important in this case, I think, for the judge to have noted something like an ola hacienda, which the government raised and which we also cite in our reply brief as well, to say, listen, just so you understand, what the trial hasn't started and what you just heard wasn't evidence and you aren't to consider it. It's important for lay persons to understand that, and they got no guidance. And the second thing is, with regard to the instructions, I'd point the court to JA 76, where some of these instructions the court was giving were not, didn't make any distinction between those 2 things. At JA 76, she tells the jury to base decisions, quote, on what you see and hear in the courtroom. Well, what they saw and heard during jury selection was indeed in the courtroom, and there was absolutely no distinction made in some of these instructions. And so I think there's a real danger of a misunderstanding by laypersons who aren't familiar with the difference between jury selection and trial and evidence that they're hearing at trial. I think there's a real danger of confusion. So for that reason, we do think it was important. And I would point the court specifically to Haley, which is a case that we cite and rely on as well. In that case, there was someone who did the same thing, who said, I have personal knowledge of what's going on in this case, and the defendants really did do what they're being accused of doing. I think that's the closest on-point case for what was said. However,
What stage of the case was that said?
it was said during deliberations, if I recall correctly. And so if the court is drawing a distinction about when, is more concerned about when it occurred, then I think Ola Sienda is instructive in that case, because it was, that concerned a juror, a potential juror, who said that she believed if any defendant had made it that far, i.e. to trial, that they were probably guilty. And in that case, she wasn't even saying anything about personal knowledge. She was just stating a personal philosophy about she believed defendants who got to a certain stage of proceedings were probably guilty. And in that case, the district court immediately stepped in, and he admonished her, and he told the entire veneer, this is not what you are to this is, first of all, not the correct standard to decide the case, and he corrected them and told them what it was. And so I think either way, if you're focused on what was said, Haley supports us. If you're focused on when it's said, Ola Sienda supports us, in that the district court should have at least made sure that the jury understand that what they heard wasn't evidence and it wasn't supposed to be considered. So if the court has further questions about that issue, I'm happy to address them, but then if not, I'll then move to the loss issue, which I'd like to address next. Okay. The statutory maximum of Mr. Umedi's count 11 sentence was erroneously doubled because the government did not produce evidence that there was at least $5,000 in loss as defined by 1030E11 of the Computer Fraud and Abuse Act, or the CFAA. First, the government didn't.
So here, he got, if I'm remembering correctly, 1 additional year to serve because of this finding.
That's correct. It was doubled from 1 to 2 years.
So if we agreed with you, he would have to be resentenced.
Correct.
Okay.
The government didn't elicit any evidence that the jury could have used to total up an amount and reach $5,000 in response costs.
I don't read that definition to mean only response costs. I read loss to be an English word that's pretty easy to understand, and that the addition of response costs is to make clear that the loss includes not only the actual loss from the crime, but the response costs, because it says basically including response costs. And in this case, there was evidence of $5,000 worth of loss, wasn't there? The amount of money that was taken from the differential between the amount of money that was taken and the amount of money that was recovered exceeded $5,000.
I would have to respectfully disagree with that for a couple of reasons. The first reason is that, and I'm glad Your Honor brought that up, because I also needed to point out that initially, Mr. Umedi's original trial counsel withdrew at the appeal stage, and he unfortunately neglected to put something very relevant to the loss question in the record. And so we had filed a motion to include an addendum to the brief with that information. There's a search warrant that was filed in district court that's under seal in district court that states at footnotes, this is in the addendum, pages 5 and 6 at notes 6 and 8, in the search warrant application where Agent Kim tells the district court that both companies got their money back.
But let me ask you this, set that aside, I'm talking about the record. Tell me what the numbers are. I thought there was quite a differential between the amount stolen or embezzled or obtained and the amount recovered. I thought both those numbers were in the record.
We addressed that in the reply brief.
Wasn't it over $1 million or something, the differential? 1.1 or 1.7 million?
There was the government relies on one witness testimony saying about $1.7 million. And as we spent some time in the reply brief explaining, the actual amount is 1.2, and everyone in this case has always understood
But that's irrelevant to the $5,000 figure. That's irrelevant. It doesn't make a difference with respect. That's clearly over $5,000. And the loss is the differential between what it's what the victim lost, and the victim lost X dollars less what they recovered. And that loss, the number is, I think, way larger than 5,000 in the record. I wish I had the numbers at hand, but I did see the numbers in preparing, and I'd love to have those numbers.
It's a difference between 1.7, which was the testimony of one of the witnesses, and 1.2, which is what all involved, including the government, have always understood to be the actual loss amount in this case.
All right, $1 million?
The indictment said 1.2.
Okay, that's 500,000, right?
That is, but
And
we'd also.
500,000 is 10 times the amount.
We would also point the court to the fact that these, again, I'll point the court to Fisher, which we cite in the briefs, which is a Supreme Court case that explains that even when you have language like this, a general clause that says any reasonable cost, which is what we have here, anytime you have a general clause that's followed by a more specific clause
I
with
know
examples.
that interpretation, but in this case, when you're measuring the crime by the amount of loss, which includes the response, clearly the crime, the essence to the crime is somebody stole something, and it's more severe if you have a large loss. And to have the inclusion of response costs, which might not otherwise be obvious. I mean, I know the exclusio unius, the Latin phrase interpretation, but you have to use these things with a certain amount of common sense, too. We don't go with formulas and end up with absurd results.
I would point the court to a quote from Fisher that says, even if it's literally covered by the language, the inclusion of specific examples afterward means that we are to draw the meaning from those specific
Why
examples.
wouldn't that be limited to the cost of remediation and that part? But the statute goes on to say, any revenue lost, which would seem to be self-evident in a separate category from cost of remediation. My question goes to the last part of the statute. So, any revenue lost, cost incurred, consequential damages incurred because of interruption of service. So it appears to limit what can be considered to those costs or loss that come about because of interruption of service.
That's right.
So did you make an argument anywhere that the interruption of service was not present here?
That has never been an issue because there was no interruption of
Well,
service.
did you argue that?
I believe that we did, but I'm happy to find a page for Your
Well, that
Honor.
might be pretty crucial because that's the language of this particular
Yes.
statute. And if you didn't argue it, then I'm not sure we get to it.
There was no interruption of service in this case.
Well, that might be your opinion. What I want to know is where did this come up in the district court and where did you argue it?
We'll locate that for Your Honor. But yes, our position is, of course, that that second prong has never been at issue because there was no interruption of service. Now, in terms of the amount that was freeze and recouped, the amount, there's a difference, of course, between the response costs. There was testimony about response costs. The problem is that the government failed to actually elicit any amounts. Some of the things that were testified to simply weren't losses as defined by the statute, like contacting customers. That's not really an identifiable cost. However, some of the things that were qualifying, such as buying a new laptop or new software, could be qualifying costs, but there was no amount solicited. There was no amounts saying how much those cost that they didn't ask the witnesses about. There also wasn't any information about why those things were technically reasonable, and that is a requirement. There does have to be a demonstration of reasonableness for those costs. It could be that they were. It could be that maybe those were purchases that weren't necessarily needed under the circumstances, but we don't know because they just weren't asked. The witnesses weren't asked specific questions about it. So I see that I'm approaching the end of my time, and
You've got some rebuttal, too.
I do,
Yeah.
I do. I'll reserve all 45 seconds for rebuttal if the court, thank you.
All right, thank you.
Ms. Withers?
Good morning, and may it please the court. My name is Laura Withers, and I represent the United States of America.
Could you start with the loss issue? You can go back to any issue, but I'd be just interested in hearing what your take is on that.
Absolutely, Your Honor. It's the government's position that the jury could reasonably have concluded that the defendant's scheme caused at least $5,000 in loss under any definition under either of the two independent bases that are before you today. This is a sufficiency of the evidence question, and so the defendant's burden here is high. I agree with you, Judge Niemeyer, that loss under 18 United States Code Section 1030E11 includes any reasonable cost to any victim, and then is followed with an illustrative list that is not exhaustive. On its face, as this court held in AV Xrel Vanderheim versus iParadigms LLC, the statutory definition of loss is, quote, broadly worded, encompassing any reasonable cost to any victim. In this case, I would note that in addition to the testimony that was before the jury from the CPP representative about $1.5 million of loss that, or of funds that were dispersed, 1.7, I apologize. There was additional evidence in the record at JA 1225 to 1226, about $850,000 specifically with respect to their vendor Rolls-Royce, and about $140,000 at JA 297 for their vendor Benchmark. And so in addition to testimony...
What's a vendor Benchmark?
I'm sorry, their vendor, the Benchmark company. So the way...
That's the name of the company?
That's correct, Your Honor.
And what was that for?
That was money that was supposed to be remitted that was sent to an account controlled by the co-conspirators in this case. And so the jury didn't just have to take the word of the CPP company representative, they also had figures.
Did you cite those in your brief as opposed to the 1.7 million cite on 287?
Yes, Your Honor. I believe that we cited both to the fact that the CPP representative testified to 1.7, and then by the time we got to sentencing and restitution, the amount that CPP was seeking was about 1.2 million, and that included, this was a case where the defendants were prolific, and so at trial we picked and chose what victims we focused on. We focused on Rolls-Royce and Benchmark because they had the highest amounts, but CPP had other affected customers, and so that is how we got to the $1.2 million in loss. And to your point, Judge Niemeyer, stepping back...
What were the categories of what were the items making up the 1.2?
That amount was the actual stolen funds in this
All right.
case.
And was there any other type of cost or loss shown?
Yes, Your Honor. And to this question about the reasonableness, the jury certainly could have concluded, based on the CPP representative's testimony about the remediation process, that that amount reasonably came to more than $5,000.
They never put a dollar amount on it. Somebody needed to ask one more question to get a dollar.
I don't disagree with you, Judge Agee. However, a reasonable jury could certainly have concluded that when the CPP representative testified that they had to get new software, 2 new laptops, they got a whole employee from the corporate office to contact every single customer, that's absolutely remediation, to make sure that they've contacted every single customer. She said they had to talk to them physically or on the phone. They couldn't send an email because they didn't trust their email, that it took 3 months. The jury certainly could have concluded that that was over $5,000.
Well, if the statute stopped with a period after revenue lost, then I think you'd have a pretty strong argument that the testimony about the 1.7 or the 1.2 or the other numbers satisfied that. But then it goes on to say revenue loss because of interruption of service, and qualifies that. Why is this a loss caused by interruption of service?
It's not our position that it is, Your Honor. It's our position that it falls under that first prong, a reasonable cost to any victim, including the cost of responding, but not exclusive to the cost of responding to any offense, conducting a damage assessment, restoring data, and program. And I would note that from a
So,
practical...
let me make sure I understand. You're saying the interruption of service limitation is just on the revenue lost part?
In reading the cases, that appears consistent with the way that courts have interpreted the difference between the two prongs, and we've always argued that the $5,000 is a reasonable cost to any victim under the first prong of 1030E11.
And this is what I had to pay some guy to fix what got messed up.
It's our position that that's not exclusively the option before this court. Again, it's an inclusive list. So as I believe Judge Niemeyer noted, responding to an offense, conducting a damage assessment may be a less obvious category of loss, and therefore it's appropriate to enumerate that to make sure that everyone understands what Congress is talking about. But we believe that the stolen funds do fall under that provision, but even if the court wants to rule on the more narrow terms, we think that the remediation testimony from the CPP representative was certainly sufficient for a jury to conclude that there was a loss over $5,000.
All right, well, I'm just slow this morning, so bear with me. Are you arguing that the revenue lost, we'll call it 1.2 million, had to be lost because of an interruption of service?
No, Your Honor.
All right, if we disagree with you, we didn't write the statute, Congress wrote the statute, that there has to be proof of interruption of service, then what does that do to your argument?
Then I would point the court to the remediation piece, which is separate and apart. That was separate and apart from the 1.2 or 1.7 million.
I understand that.
And so that would be the cost of responding to any offense, conducting a damage assessment, restoring data, a program, a system, or information to its condition prior to the offense. And it's certainly new software, multiple laptops, an employee devoted to this for 3 months, contacting every customer personally on the phone, not just, copy pasting in an email. The jury certainly could have concluded that caused a loss, a reasonable
But
loss.
as to the 1.2 million, that plug figure for revenue lost, you agree that there was no argument or evidence presented that loss was caused by an interruption of service, whatever that is?
That's correct, Your Honor.
Okay.
Okay. I'd like to move on to the juror issue if there are no other questions on the loss.
Let me just go back to follow this. I think
Of course.
this is a fairly difficult issue. It's not a slam dunk for you by any means. And the definition says the term loss means any reasonable cost to any victim, comma, including, Is the number you're using, the 1.7 million, a cost to any victim?
Yes, Your Honor. I think 1.2 would be the safer number here because that was the actual.
Okay, 1.2, I don't care about the number.
Yes, yes.
And why is that a cost to a victim?
Because it is something that they are out of pocket as a direct result of the defendant's conduct in this case. I want to point to a practicality here, too. Hypothetically.
Well, while you're doing that, I mean,
Yes.
how's that any, what's the difference then between a cost and revenue loss then as to this 1.2 million?
Revenue lost as a result of an interruption of service would be, your system goes down and, you are losing 30 grand a day while your system is down. That is a different type of lost revenue from I hack your computer and I steal $1 million from you. It's a different type of harm, affected in a different way, but nonetheless, it hurts the victim.
So it's a loss and a cost.
Correct, Your Honor. And I would just note to that hypothetical of I hack into your computer and I steal $1 million, at sentencing, my guidelines are very high based on that loss amount. It doesn't really make sense as a practical matter that my sentence would nonetheless be capped at 1 year if I steal $1 million. And so thinking at it from the perspective of what Congress is seeking to accomplish here, it's clearly to tie potential punishment to the size of the harm. And so it wouldn't make sense to have a situation where hundreds of thousands, millions of dollars are stolen from a victim and someone's potential sentence is capped at 1 year. But again, we do believe that this court could rule under either piece of this, finding that the 1.2 million is a reasonable cost to the victim, and or that the jury could have found a reasonable loss over $5,000 based on the testimony about remediation.
Do you find a difference, or do you think there's a difference between the word loss and cost?
No, Your Honor, I don't. I think it is a cost to a victim. It's basically what you would say on a tally sheet, right?
Well, I would think a cost is something you pay to have something, whereas a loss, you did nothing, you just lost it because of the theft. But I think there may be a difference between a loss and a cost.
I think that certainly if you're looking at a tally sheet of, revenue coming in and revenue going out every month, it would be a cost to the victim if you're out, $1.2 million. But again, we think you could rule under either piece of the argument.
Do you think this enhancement is limited to cost as opposed to a loss?
No, Your Honor. I mean, 1030C4, big A, little I, 1, has the enhancement as loss to one or more persons during any 1 year period. And then as part of defining loss, it says any reasonable cost. And so I do think that those two thoughts are bound up together, that we're looking at a loss, we're looking at a reasonable cost to a victim of a particular scheme. I would like to briefly touch on the veneer issue, if I may. I do think that Ola Hacienda is the right framework here from both a factual and a legal perspective, and that's this court's case from 1997. In both cases, Judge Brinkema brings in the jury veneer. They're sworn before the process begins. She's asking questions to get at potential prejudices. Judge Agee, as I believe you pointed out, the answer that is given here is fairly vague. It's not specific to this case. And at the end of the process, Judge Brinkema asks, is there any reason that you, the jury veneer under oath, cannot be fair and impartial? No one responds. She asks defense trial counsel if he would like to have her ask any further questions. He doesn't have any questions that he wants about this particular juror issue. And so as in Ola Hacienda, Judge Brinkema strikes that juror and she swears in a presumptively impartial jury that will follow her instructions. I do disagree with opposing counsel on the idea that the jury was not instructed about, for example, what evidence is. They were told what evidence is. They were told that the statements of the judges the statements of the parties are not evidence. It was made clear in the instructions that what they were and were not to consider as part of their deliberations. And so as in Ola Hacienda, the defense bore a very heavy burden here in attempting to strike the entire veneer. As in Ola Hacienda, Judge Brinkema properly questioned and instructed the prospective jurors. She made the decision not to draw additional attention to the veneer person's answer by asking further questions. She asked the defense in this case if they wanted additional questions. They didn't. And so she, as in Ola Hacienda, this court should determine that Judge Brinkema acted squarely within her discretion when she was dealing with the question before her. And just to distinguish this situation from the kind of Remmer line of cases that opposing counsel has relied on, I agree that there seems to be something in these cases different about voir dire. I've yet to find a case where the Remmer line of cases was applied to voir dire. Even the Johnson case that the defense cites is not a voir dire case. And that seems to be speaking to the fact that here we have a situation where the juror is responding to a direct question from the judge. This is not an unauthorized or an extrajudicial communication. It's in court, it's on the record, therefore it's not private, and it's with all the parties present, and therefore with the full knowledge of the parties. That allows Judge Brinkema to make an independent determination about what was said and whether there was prejudice from that. It gives the defense the opportunity that he was given and declined in this case to ask for clarifying questions with respect to the effect on the rest of the veneer. And it means that there's an opportunity to address whether or not prejudice arose. Here, the defendant has not met his burden to establish that there was that this rose to the level of a presumption of prejudice where any kind of hearing was required, and as in Ola Hacienda, Judge Brinkema did not abuse her discretion in the way that she handled it. I'm happy to deal with, to answer any of the questions about the voir dire issue, or if there are any other questions about the sufficiency itself separate from the loss. But otherwise.
I must say, as I'm thinking about it, I'm still thinking about this question of loss and cost. And I'm wondering whether Congress was focused more on damages caused in the sense of what its cost to rectify and reassert itself, as opposed to just loss. It may be one and the same, and I really have to think about that, but your argument's helpful. Thank you very much.
Thank you.
We'll hear now from Ms. Thomas. Tom.
Thank you, Your Honor. All right, I'd like to start first by, I think if I understood opposing counsel correctly, and please correct me if I'm wrong, but I believe there's no dispute that any of this falls under prong 2 under the interruption of service. Yeah, I think that has always been the position. Of course, I was not trial counsel, but my understanding of the record is that that was never argued by the government below. It's not argued by them here today. And our briefs referred only to, quote, prong 1 losses, because those were the only kinds of losses that Mr. Umedi was alleged to have caused. So just to round that out. The second thing that I would say is that, to be very clear, no one's out of pocket this money. No one is out of pocket this money at all, because as the district court record has included in our addendum, I'm quoting from it, Benchmark reports that it was able to freeze and recoup the stolen funds. That's all of them.
What's the addendum?
The addendum is what we filed to the brief.
Yeah, but that wasn't before the court, was it? It wasn't even part of the record.
It was part of the district court, yes.
It was before the district court?
Absolutely. It's
Okay.
under seal in the district court, and which is why we filed it, or sought to file it.
What's the source of that statement?
It is a search warrant filed by Agent Kim. He is filing a search warrant for, he's asking for a search warrant from the district court, and he tells them.
Was that put before the jury?
Not before the jury. It was before the district court,
What do we
however.
do with that?
How was it before the district court? There was never any argument about that, was it?
The district court certainly read this, I would assume, before it approved this.
That's not what I'm asking you. What I'm
Okay.
asking you is, did trial counsel ever raise whatever was in this other document that was not
No.
introduced into evidence?
I don't believe he did.
Okay.
Not to my knowledge. As to Judge Niemeyer's question regarding the economic losses, I think Your Honor is hitting on an important distinction that perhaps I could have articulated.
Well, I don't know if
little
it's a
bit
distinction. I suggest that there may be distinction. The question is, I think the provision starts out to be any cost from a victim, and then it uses the word including. Now, any cost to a victim, if a victim lost money, is that a cost to the victim? And that's my question. The statute seems to use loss and cost interchangeably, so to speak. That's what causes difficulty for me. If the whole statute was purely intended to be based on the distinction between the word loss and cost, then they would have never used the word loss. And they use the word loss, and then they defined it as cost. And
I would agree with my.
cost to a victim, and the question is, what is a cost to a victim?
I
If
would-
they steal your money, is that a cost to a victim?
I'd agree with opposing counsel that a loss is, you have to, the context of these statutes is very important. This is a computer fraud and abuse statute. And the reason why that's important is because economic losses are something else. They're wire fraud. He was convicted of wire fraud. That's the wire fraud, those economic losses, the money the companies inadvertently paid to fraudsters. The
Well, this
Computer
is-
Fraud and Abuse Act.
A cost is economic, too. I mean, economic just refers to money, so to speak.
That's, okay, I concede that, but the point is, money paid to fraudsters is wire fraud. There's a different statute that covers that, and he was convicted of that. But the CFAA is very specifically designed.
Does that separately go into the calculation of his guidelines, setting aside the enhancement?
So the guidelines operate on intended or actual loss, whichever was greater, and because the intended loss was indeed 1.2, you can use that for the guidelines. The statute, however, is only concerned with actual losses. There's no intended portion to the statute. That's, again, another important distinction. But you have to keep in mind that the
I mean, I don't remember, so I don't know, but in calculating the guidelines, not this statutory enhancement, but the guidelines, was whatever the wire fraud losses part of the calculation?
The intended losses,
Or intended
yes.
losses?
Yeah.
They
yeah.
were?
Yes.
Okay.
I believe so. But again, the CFAA is it's a separate statute very specifically meant to address computer intrusions. And the way in which it arose was, like opposing counsel said, if you hack Amazon and Amazon is down for a day and a half, that's certainly a couple billion right there because they're not making sales. That's the sort of thing that CFAA was meant to address. And so I would point this court, if I could just read I see I'm just about out of time, if I could just read to this court a brief excerpt from Vanderhei, which is a decision of this
You
court.
can read that, and then
Yes, I'll conclude.
you won't get a ticket for the red light.
Thank you. I appreciate that. It says that the statute contemplates, and I'm quoting here, consequential damages of the type sought, cost incurred as part of the response to a violation. That's something that happens after the violation is discovered. So that's responding to the offense. And I'm still quoting, investigate and take remedial steps, hours of valuable time away from day-to-day responsibilities, which we had testimony about. The problem is that no one asked an amount. That's the problem with the trial testimony on that. And so I just refer this court back to Vanderheide.
All right.
Thank you for
Thank you,
allowing
Ms.
me to
Thomas.
go over.
Yeah. We'll come down and greet counsel and proceed on to the last case.
I'm ready to go home. Thank you.
The next case we're going to hear this morning is United States versus McDonald. And Ms. Trodden, whenever you're ready, we'll hear from you.
Good morning, Your Honor, and may it please the court. I'm Erin Trodden on behalf of Jennifer McDonald. The district court made several errors in this case that singly and in combination require reversal. I'd like to focus today on two of those errors: the denial of Ms. McDonald's motion for judgment of acquittal on the aggravated identity theft charge, and the denial of her motions for mistrial. First, with respect to the aggravated identity theft, Ms. McDonald's...
Does this relate to the use of
Yes, it does.
Okay.
Ms. McDonald's conviction under this statute cannot be squared with the Supreme Court's decision in United States versus Dubin. In Dubin, the Supreme Court made clear that for an identity theft to be aggravated under the statute, in other words, for it to be committed during and in relation to another offense, it must be at the crux of what makes that underlying offense criminal. In other words, it must do more than be ancillary to the offense. It must do more than facilitate the offense. It must do more than be a but-for cause of the offense. It must essentially be the basis of what makes that offense criminal. In other words, under the Supreme Court's construction, the underlying offense has to rely on a fraudulent who rather than a fraudulent how or why. That's not the case here with respect to the use of Mr. Tran's means of identification. In this case, the underlying offense was the wire fraud charged in count 1. That related to a transfer of $2 million.
That's $2 million.
Yes, Your Honor.
All right, and that was set up in a contract with Mr. Tran as the purchaser. Who signed that contract? Who signed the contract?
Not Mr. Tran. That contract, however, is not the basis of the wire fraud in count 1. That is sort of the second step.
Without the contract, there would be no transfer.
No,
Under the contract, who was it that changed the names in order to facilitate the wire transfer and signed it for Mr. Tran?
not Mr. Tran, and that's, for purposes of this appeal, we agree with that. But, Your Honor, I think we have to take a step back because the transfer that is charged in count 1 is the transfer of the $2 million out of EDA's bank account into an account at the settlement company at TLC Settlements. That transfer is not based on that contract in any way. That transfer has nothing to do with that contract. That transfer occurs because, under the government's evidence, Ms. McDonald represented to First Bank, which was EDA's bank and held EDA's funds, that those $2 million were needed in order to fund an escrow that the Virginia Department of Transportation required. In other words, which they did not. This was the government offered evidence to the effect of this was a fraudulent statement. But that did not involve the use of Mr. Tran at all. So, in other words, if the government had not offered any evidence regarding Mr. Tran, regarding the fraudulent use of Mr. Tran's identity, the government would still have had sufficient evidence to prove the wire fraud in count 1. The wire fraud in count 1 did not rely on the use of Mr. Tran's means of identification at all. The district court erred in denying the motion for judgment of acquittal, relying, I think, on the fact that the proposition that you raised, Judge Agee, that the use of the means of identification was involved in the greater scheme to defraud. But that's not actually the question that Dubin requires courts to ask. Under Dubin, the court has to look at what is the heart of the conduct that makes this offense criminal. And looking at that, we look at the elements that make the offense criminal and what the government's proof of those elements are. Now, wire fraud only requires a scheme or artifice to defraud, an intent to defraud, and a wire transfer in interstate commerce. Once that wire transfer in interstate...
What's the scheme? What's the scope of the scheme?
The scheme to defraud alleged in the indictment is the scheme to defraud the EDA. So it's extremely broad. The use of Mr. Tran's means of identification broadly is part of the process that the government offered proof of how this money ultimately got into Ms. McDonald's pockets. But that's not required for wire fraud.
Isn't it part of the scheme?
It may be part of the scheme, but Dubin could not be clear that the court looks at what makes the offense criminal. And a scheme to defraud is not a wire fraud. Wire fraud requires more than that. And so looking at what makes this offense of wire fraud criminal.
You're insisting that Tran be part of every element, but it seems to me it just has to be, I mean, if you don't have a scheme, you don't have a claim, do you? You got to have a scheme.
A scheme is necessary but not sufficient, Your Honor.
Well, I understand that. None of the elements are sufficient. They all have to be there. But the question is, how important is it? Does it go to the core criminality aspect?
And I think that is what that question, my point earlier, answered with respect to, if you didn't have Kurt Tran in this at all, could the government still prove wire fraud?
Well, they have to start, you want to just focus on the transfer, but the whole scheme, it seemed to me, whether it's necessary or not, it was factually there, that Tran was the mechanism by which she carried out her scheme, it seems to me, but maybe I'm missing something or don't understand the facts. But
Tran is the scheme to defraud alleged in the indictment is extremely broad, and it's just a scheme to obtain money from the EDA through a variety of means.
And that one element, as you point out, is not sufficient for the whole crime, but it's a necessary element. And the question whether it's an important element, I think, is the test, sort of, the core of criminality. It can't be something collateral or frivolous, but I think your argument is tending to suggest, and maybe it is, that's the way it's being done, but that it has to, I don't know, he has to be involved in every element?
I think that the court has to look at what does the government need to prove in order to prove this wire fraud.
Yeah, but we agree they have to prove a scheme. That's one element.
Right, but the government proves this, the government proves the wire fraud. There's another scheme. The government proves the wire fraud without Mr. Tran. If Mr. Tran's not here, the government still proves the wire fraud because Ms. McDonald made this representation to First Bank that EDA needed this money for a completely different reason that was also fraudulent. If you look at every post-Dubin aggravated identity theft case that the parties have identified, in every one of them, the underlying offense has relied on the fraudulent use of someone's identity. And I'd point this court to the opinion in United States versus Jackson, which this court recently decided, where dealing with the fraudulent declarations submitted, which were the basis of the identity theft charge in that case, and also the basis of the fraudulent statements to Medicaid, who created and signed those declarations was essential to the qualifying offense's fraud. In other words, by submitting these fraudulent declarations to Medicaid, the defendant in Jackson both committed wire fraud or committed the Medicaid fraud offense and committed aggravated identity theft. That's not the case here.
That was also forgery.
It was, Your Honor. And the Second Circuit recognized in...
But how in this case, so you have a wire transfer, but then Ms. McDonald doesn't have her hands on the money. She didn't get her hands on the money except by the use of Mr. Tran's name.
That's correct, Your Honor. And the district court properly instructed the jury that wire fraud does not require the defendants to get their hands on the money. A wire fraud is complete.
Again, that's part of this whole scheme. If you don't have the forgery to begin with, she doesn't get the money. If you don't have the forgery afterwards, she doesn't get the money. And it seems like you're carving out this very pristine element, if you want to call it that, in the middle that just ignores the whole package.
I want to make sure I correct you, Your Honor, with respect to she didn't have the forgery to begin with, because what got the money out of the EDA's accounts and into the settlement company's account did not relate to Mr. Tran, did not use his means of identification. It was a different fraudulent statement that got that money into the settlement company. There's no testimony from the settlement company that they required any particular verification or information in order to be able to accept that money. the wire fraud is complete, and we're talking about the offense of wire fraud. Dubin is looking at what makes that conduct criminal, but the offense of wire fraud is complete when the wire transfer occurs. The scheme to defraud in that case would have been telling the EDA's bank that they needed to transfer this money
But
for
why
this
do you get to
fictive.
narrow down the scheme that was actually approved? In other words, the scheme that was actually approved involved Tran, and you're suggesting that, well, that was unnecessary to prove it.
It
But-
was
But
unnecessary.
they did prove it as part of the scheme leading to the wire fraud, and their argument is that it's element-based. It's that you don't have to have every element linked to it. And the question is whether Durbin requires that every element, or pick a particular element to make Tran involved. I'd like to go reread Durbin, but
And I would suggest that, Your Honor, take a look also at Gladden and Omotayo. So the Gladden case may be instructive because in that case, there are actually two aggravated identity theft charges. One of them is sustained, where it's the defendant is sending fraudulent information regarding which patient is receiving medication. That's aggravated identity theft. They also change who is receiving, whether the patient is actually getting the medications, if they're medically necessary. And the court found in that case, the use of the patient's information is ancillary. And I think what your question goes to is the use of Mr. Tran's means of identification here ancillary? It's part of the broader scheme by which this money was Ms. McDonald got this money, but it's not part of the wire fraud charged in count one.
So if we agreed with you on this, on the wire fraud argument, but we didn't agree with you on anything else, what would happen?
This case would be remanded for resentencing.
you get 2 years off, right?
We would certainly ask for it, Your Honor.
Oh, well.
Now, I would like to turn to the mistrial motion, if I may, unless the court has other questions regarding the wire fraud. The district court abused its discretion in denying the mistrial in this case. Essentially, there are some hiatuses in trial that are so long that we can't reasonably expect jurors to be able to remember and make decisions based on the evidence that they heard after those hiatuses, and this was one such. In combination...
You know, there's a couple of issues on this, and I just bring them up so that you can focus on them. Number one, it looks like this is almost squarely in line with the Smith decision, with 32 days there and 34 days here. And the various things the court said there were sort of verbatim here by this court in managing the time. This case had the additional element that there was some suggestion that the defendant might have been malingering and taking advantage of these times and creating these times. She was seen shopping and this type of thing. And the court was witnessing all this, interchanging with the jury and trying to keep the jury engaged, just as in Smith. And it seems to me this is a highly discretionary and on-scene type of judgment that has to be made. And it seemed to me it has to be pretty clear if we're going to step in and say it has to be a do-over in the circumstances where I think Smith seems to be paralleled here. And in addition, most of the time is attributable to the defendant in this case. But those are my concerns, and you can express a response.
Thank you, Your Honor. I would love to respond to all of those. First of all, yes, this is an abuse of discretion standard, but that discretion is not boundless, as this court knows. With respect to Smith, there are some salient differences. First of all, this was longer. Smith was 32 days. This was a 37-day hiatus that was unexpected, and that was on top of prior unexpected pauses of about 11 days. Second,
Most of which counsel consented to.
yes, and we're not, the basis of the mistrial motion, to be clear, is not those prior pauses, but as the district court considers whether there's any means less than mistrial that it can use to address this, it has to look at the entirety of the case. It can't have blinkers on as to what has gone before. But second, and I see my time is up, but I would love to respond
Go
here.
ahead and address that. I'll give you another minute. Yeah.
Thank you, Your Honor. In Smith, there were co-defendants, and those co-defendants opposed mistrial, and that raised constitutional questions that I think the court was very concerned about, and one reason why they did not grant the mistrial was because of the presence of those co-defendants opposing mistrial. Finally, in Smith, the judge knew that the pause was going to occur and gave a keep fresh instruction at the beginning, when the information still was fresh in the jury's mind. That didn't happen here. It was sort of a moving target when the jury understood that trial was going to resume, but the judge didn't give any kind of a keep fresh instruction until much later, until at least a week, I believe a week had passed. Question whether any keep fresh instruction, frankly, would do the job given the 37-day hiatus in trial. But finally, Your Honor, and I do want to address the allegations of malingering here, because the district court had a fulsome evidentiary hearing on this. They heard from Ms. McDonald's doctors. They heard extensive testimony about this. And at the end of that, the district court found that they did not find malingering. So the government's now attempting to suggest that that's an issue, but the district court fully addressed that and did not find it, and this court should reject that.
Thank you.
Thank you.
Yeah. All right, we'll hear from Mr. Juhan, Juhan?
Juhan, Your Honor.
Juhan, sorry.
Happens all the time, Your Honor.
You know, in Europe, it could be Johan, but you have a U there instead of an O.
May it please the court, Keiko Juhan for the United States. If I may begin by answering first, Judge Agee, your factual question about the Dubin issue, and then Judge Niemeyer, you asked some legal questions about the Dubin issue, and then open it up to whatever questions that the court may otherwise have. Judge Agee, about the facts in this case, I'd point you to JA 1322 to 23. That is where Ms. McDonald represents to the settlement company that this money that is part of the wire, the $2 million that she is trying to smuggle out of the EDA's account, she trades on trans identity in order to convince them to accept the wire. She says, this money is Mr. Trans. He accidentally, this locally known businessman,
So this is before the $2 million is transferred?
This is the same day, yes, on September 14th is the...
Well, the question is, has the $2 million been transferred yet?
Your Honor, because we stipulated to the wire, I can tell you that it is the same day. I don't think because the wire is stipulated to, we can say exactly the chronology. I think it's a fair inference to draw in our favor from the record. In addition to that wire, that same...
Well, based on opposing counsel's argument, she says that the defendant got the $2 million transferred based on this claim that the EDA needed it for some environmental remediation or something like that. And that was unrelated to the transactions with Mr. Trans. So if that's the case and there were discussions after the fact, after the wire transfer was already completed, that would seem to be a fairly salient fact. So I take it you're saying that you can't tell us one way or the other.
There is not direct evidence in the record, to my recollection, and I will double check after, that specifically gives the chronology of that particular point. But to further elaborate, Your Honor, and just to make clear that we're talking about the same thing, she is correct that there's this VDOT story that is told to...
Well, regardless of the scenario, was the testimony at 1322 that you're referring to linked to the $2 million transfer?
Yes, Your Honor. It is about, that testimony is about the settlement company, a woman named Tracy Bowers, being told by Ms. McDonald, this $2 million that she's smuggling out of the EDA's account is Mr. Tran's money. Mr. Tran put it in the EDA account and, quote, we can't keep it there, we, the EDA. So that was the story that she told the settlement company, the one that processes the wire, the transaction, as the holder of that money. That's the story that she told them.
But that's after they've gotten the $2 million. right?
I believe it's the same answer that I just gave to Judge Agee, in that it's not.
That's important, though, isn't it? Because that's what Dubin says. It has to be the crux of it. All of the circumstances that might give rise to a scheme does not make it crux. And that's the whole difference. And the key is, how did, the money get sent to, that's a different type of situation in terms of identity there, isn't it?
There is some difference. I agree with that, Your Honor. I guess what I would also say, and this goes to Judge Agee, your points also, is the transaction we know happens on the 14th, but on the 8th, 9th, and the 13th, there are also facts in the record showing how she uses trans identity in order to essentially grease the skids of that transaction as well. And I was just happy to provide those sites to the court. On the 8th, at JA 6637, that's when she sends the forged document that Judge Agee, you mentioned earlier. That's when she sends that to the settlement company.
I think, this may end up being we may be required to do a very granular analysis of this. So I think the pertinent facts deal with what representation, if any, was made to get the money from the holding bank to the recipient bank. And it seems like Mr. Tran's name would have to be used on one end or the other of that transaction and not necessarily what went on before or what went after.
Your Honor, I think that's a fair, I understand what Your Honor is saying, and here's where I would try to distinguish it. In between those two endpoints is the settlement company, the one that actually holds that money between the two banks. If that settlement company balks at that transaction because she says, this is just the EDA's money that I'm taking out of the EDA's account, then that transaction doesn't happen.
So the bank sent it to another bank, or they sent it to the settlement agent?
My understanding, Your Honor, is they sent it to the settlement company. TLC is the settlement company. And trial counsel is here in the courtroom, and I will consult with them after this to make sure that I am correct on that and let the court know. But that is my recollection from the record. And so I think those are kind of the factual circumstances leading up to it. She forges Mr. Tran's identity. She tells the story, and this is, I think the post-Dubin through line of these cases from the circuit courts is when an individual pre-selects someone's identity in order to essentially, not as an ancillary feature, but to make the transaction go. It doesn't have to make the transaction go on both sides. It can go on one end or the other, or even in the middle, as was the case here. That is a satisfaction of being a key mover, as one of the phrases from Dubin says, of the fraud.
Well, in the indictment for the aggravated identity theft count, and in the argument, was there any tie to anything other than the wire transfer as the basis for the aggravated identity count?
If I understand Your Honor's question, the wire fraud count on September 14th
Right.
that's the predicate of the aggravated identity.
That's what I should have said, the predicate.
Yes, the predicate offense is, as Judge Niemeyer talked about legally, this compilation of elements. And I think this goes to the legal discussion we were having, Judge Niemeyer. What is odd about their argument is that Dubin comes in and has a very holistic, impressionistic analysis. It uses fairly vague terms like at the crux of, a key mover in. It does not single out a single element of the predicate offense. Dubin was a healthcare fraud case as the predicate offense. They didn't say, well, you have to deal with a health company that does an interstate commerce. What we look at, what we think Dubin requires or asks for, is a holistic assessment of essentially the common nucleus of operative fact, to borrow from civil litigation terms, of what was this predicate crime and how was this means of identification being used.
Do I understand you be arguing that the record shows here that Ms. McDonald used Tran as the justification and the persuasion for making the transfer?
For the settlement company, yes. For the settlement company. And also, yes, sir.
That was the second transfer, wasn't it? The first transfer is different. Is that, which one did you charge in terms of the offense, the predicate offense, in terms of the wire fraud? Because that's what you look at. It's the money coming from what? Going from EDA to who? To whom?
It's from the EDA's bank, this is stipulation number 3, to the seller, Mr. Vaught's bank is what I thought.
Right, and that's what you charge.
Correct.
That's the only wire fraud charge, right?
That's the only wire fraud in that, as that predicate. Yes, Your
So
Honor.
the wire transfer from the EDA's bank, I thought you said went to the settlement company.
That's my understanding, Your Honor, yes.
Well, you just said the different right now.
To another bank.
You didn't charge that, though. That's the key to here. You're trying to charge to go transfer, the next transfer, and saying the identity fraud came with the second one, but you charged that from EDA's to the bank. That was completed at that point. That's the one you charged. That's the predicate offense. So that's what Dubin says. The crux of that predicate offense has to be identity, correct?
Could I understand the facts again, what you understand the transfers?
Yes, Your Honor,
And start with the EDA's bank.
yes, Your Honor. And again, this is my understanding, I will doubly confirm this after we're done, is that the way we charged it is that the whole wire is a transfer from one bank to the other that went in interstate commerce. That is stipulation number 3 that the parties agreed to.
Well, you said earlier it was a transfer from EDA to the settlement company.
And I just want to explain, Your Honor, I don't know, honestly, that stipulation disambiguates between the two. And so that's why I'm struggling to give you a direct answer, is because standing here today, and this is on me for not knowing this better, but I think the stipulation doesn't exactly make clear.
Well, what in fact happened? Don't we know where the money went?
Yes, it went.
It went from the EDA bank to where? What was the next landing point?
My understanding is it's held by the settlement company, and then that gets transferred to
no,
the
it-
receiving bank of the seller.
Settlement company's bank.
Yes.
owns the money.
Are you sure about that?
Not the settlement company's bank, the settlement company.
Are you
But
sure about that in terms of, as counsel, you represent to the court that it went, what bank did it go from EDA to what, to where?
Your Honor,
You can't tell us, can you?
I apologize, yes, Your Honor.
Right.
I don't want to misrepresent the
I know,
facts
I
of it.
appreciate
Well,
that.
where
yeah.
would I find that evidence? In other words, in the record, if you were looking, it went from the EDA bank to whom? That's the only question.
Your Honor, I believed coming into this argument that it went from the EDA's bank to TLC, the settlement company. Yes.
And she told the settlement company that.
But they didn't give the settlement company $2 million in cash. I mean, it had to go to some, why don't you send us a 28J letter if you're able to find this? Because I think we're asking questions about some fairly essential facts.
I would be happy to, Your Honor, and I apologize that I don't have better answers on the facts of the record in this case. To Your Honor's point about legally, though, we do think that it is not a wire by, we don't single out a element. So I think today the questions have suggested that we do try to look at the transaction holistically. I'm happy to talk briefly about the delay issue. Judge Niemeyer, obviously you're familiar with Smith. I think we would add an important fact to Smith, which is to say that's even stronger in this case, is that the district court found as a fact below that this particular jury was attentive, and further, they conceded that below. So in addition to some of the other reasons showing that this case is very substantially similar to Smith, that is a fact that is even more in favorance of affirmance in this case. Additionally, there was, of course, just overwhelming evidence of guilt in this case. I'm happy to discuss that if the court has any questions about that or any other issues. Thank you.
All right. Ms. Trodden, you have some rebuttal.
So you can start, if you know, if you can tell us where in the record we find where the money went from the EDA's bank to who?
So the indictment charges, and I'll start with the indictment. The indictment in count 1, the wire fraud charges that the wire transfer of $2 million from an account held at First Bank and Trust in the name of the EDA to an account held at Union Bank and Trust in the name of TLC Settlements. So the wire fraud charged in count 1 is the movement.
Says the money went from the EDA's bank to the settlement company.
Yes, Your Honor.
Okay.
That's the wire fraud charged in count 1. I think,
Just, What page is that on in the appendix? Do you have that?
Page 41 is the indictment. Testimony about the bank and the bank's representations in Robert Boyd's
And now,
testimony.
Which bank are we talking about?
First Bank, EDA's bank, the originating bank that held EDA's money. At JA 1486, he testifies about Ms. McDonald telling him that the VDOT needs to see $2 million in an escrow at TLC settlements by a certain date. But I want to clarify that there was never any testimony that TLC settlements required any particular representation by Ms. McDonald, or really anything, in order to accept this money. And I would point the court to JA 6623. This is an email sent by Ms. McDonald to Tracy Bowers at TLC Settlements on August 22nd of 2016, so well before any transfer occurs, where she says, Tracy, I have some funds that need to be wired to you guys for a closing you're handling in September. Could you send me the wire instructions and I will have that sent to you? And Tracy responds, here you are, my dear, and sends the wiring instructions. At that point, Ms. McDonald can wire the money. Tracy Bowers doesn't ask, who's this for, what this is about. And in fact, on August...
She can wire the money out of the EDA's account.
Right, which is the wire fraud alleged in count one. On August 29th, Tracy Bowers says, writes back to her and says, I don't see we've received a contract on this. All I have is your money, LOL. I think that money is referring to the earnest money at that point rather than the deposit of the $2 million, since that didn't happen until later. But it's clear they're accepting the money without any particular documents attached to it. Robert Boyd, who was the president of First Bank,
Is it
EDA's bank.
essential that the bank know the purpose? In other words, if McDonald had structured and set that transaction up using TRAN, even though she didn't inform the bank and they didn't require it, would TRAN be at the core of that transaction then?
When you
I mean,
ask,
that's what they seem to be saying, that she has created a structure or a scheme which uses TRAN's name in order to justify that money out. Now, when you talk to the bank, she doesn't explain that. She just says this is transfer this money for a closing. But at some point, somebody's going to look at it, and she structured the deal in the name of TRAN. Is that sufficient to engage TRAN in it?
that's what she told TLC Settlements, but that's
Yeah.
not what she told,
I understand, it doesn't matter, I'm not talking about who told what, I'm talking about what in fact was her justification for the transfer.
Her
And was
justification.
TRAN was the name used for that whole transaction, right?
The justification for the transfer of the $2 million out of EDA's account into the settlement company, TLC Settlements account, did not involve TRAN. It involved the statement to the
Not
bank.
statements too. What was the purported reason that the settlement company was getting the money?
The settlement company,
Why were they were getting the money to pay who?
they were getting the money in order to, this is the part that involved TRAN as the representation she made to the settlement company. But I want to clarify something as well for you, which is the wire fraud is complete when the wire is sent. If the wire bounces back.
I understand, that goes to the sufficiency, but the question goes factually. If this was a transaction created by her using TRAN, even though she didn't inform the parties at the time, she was creating the documentation to justify the whole transaction. It seemed to me notice isn't necessary, but that goes to the scope of the scheme, which is the whole transfer is carried out in the name of TRAN, even though she didn't tell the banks.
May I respond to that, Your Honor?
Please, of course, yeah.
I think that is very similar to the Second Circuit case Omotayo, which is a case where the Second Circuit found that wire fraud was not actually sufficient under Dubin, where the defendants had created a fraudulent document with the victim's identity, but it wasn't actually central to the scheme and they didn't actually use it. And the Second Circuit recognized the mere fact that you're using someone's identity fraudulently in relation to a scheme is not sufficient, and I think this is similar here. I think we're in agreement with the government that the court has to look at this holistically rather than by element. I think the government is the one that has brought the elements question into this, but looking holistically at the offense of wire fraud charged in count 1, that offense, that transfer of the $2 million out of EDA's account, did not rely on Kurt Tran and would have been proven absent Kurt Tran. Thank you, Your Honor.
All right, we'll adjourn court for the day and actually sine die and come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.